Welcome to our comprehensive guide on the General Data Protection Regulation, or GDPR. In the next few minutes, we'll demystify this crucial legal framework, ensuring you have the practical knowledge to protect personal data effectively. Whether you're a legal professional, a team member handling data, or just curious about privacy, this training is for you. Let's start with the basics. What exactly is GDPR? It's a landmark EU law that came into effect in the 25th of May 2018, setting a new global standard for data protection. Its full name is the General Data Protection Regulation EU 2016/679, and its primary goal is to give individuals control over their personal data. Think of it as a digital bill of rights for the 21st century. To understand GDPR, we need to know the key players. First, there's the data subject, that's any individual whose personal data is being collected, held, or processed. It's you, me, our clients, and our customers. Next, we have the data controller. This is the organization or person who decides why and how personal data is processed. They are the ones in the driver's seat, determining the purpose and means. For example, a law firm collecting client information is a data controller. Finally, there's the data processor. This is a separate entity that processes personal data on behalf of the controller. Think of a cloud storage provider or a payroll company. They don't own the data or decide its purpose. They simply provide a service. The controller directs the processor, and both have obligations to protect the data subject. Now, let's dive into the heart of GDPR, the 7 core principles. These are the pillars that every data handling process must be built upon. Imagine them as a wheel, where each spoke is essential for the wheel to turn smoothly. The first principle is lawfulness, fairness, and transparency. This means you must have a legal reason to process data. You must not process it in a way that is unfairly detrimental, and you must be crystal clear with people about what you're doing with their information. No hidden clauses or confusing jargon. Second is purpose limitation. You can only collect personal data for specified, explicit, and legitimate purposes. You can't just collect data now and decide what to do with it later. If you collect an email for a newsletter, you can't then use it for marketing profiling without separate consent. Third, we have data minimization. This one is simple but powerful. Only collect and process the data that is absolutely necessary for your stated purpose. If you only need a name and email to send a report, don't ask for a home address and date of birth. Less is more, and less is safer. Fourth is accuracy. Personal data must be kept accurate and, where necessary, up to date. You must take reasonable steps to erase or rectify inaccurate data without delay. Outdated information can lead to incorrect decisions and harm the data subject. Fifth is storage limitation. You shouldn't keep personal data forever. It should only be stored for as long as is necessary for the purpose it was collected. Once that period is over, it must be securely deleted or anonymized. This prevents the risk of old data being breached. The sixth principle is integrity and confidentiality, which is all about security. You must protect personal data against unauthorized processing, accidental loss, destruction, or damage. This involves using appropriate technical and organizational measures, like encryption, access controls, and staff training. And finally, the seventh principle, accountability. This is the big one. The data controller is responsible for, and must be able to demonstrate, compliance with all the other principles. You can't just say you're compliant. You have to prove it through documentation, policies, and audits. The burden of proof is on you. So, we've covered the rules for organizations, but what about the individuals? GDPR grants powerful rights to data subjects, giving them real control. Let's look at the main ones. First up is the right of access. This allows individuals to ask what personal data you hold about them, why you're processing it, and who you're sharing it with. It's their right to look behind the curtain. Next is the right to rectification. If a person finds that the data you hold on them is inaccurate or incomplete, they have the right to have it corrected. Then there's the famous right to erasure, also known as the right to be forgotten. In certain circumstances, an individual can request that you delete all their personal data. For example, if a client ends their relationship with a fitness service, they can ask for their workout history and personal details to be permanently removed. Following that is the right to restrict processing. In some cases, like a dispute over the accuracy of data, an individual can ask you to temporarily stop processing their data, but not delete it. We also have the right to data portability. This allows individuals to obtain their data from you in a structured, machine-readable format and transfer it to another provider. Think of it like taking your phone number with you when you switch mobile carriers. Finally, there's the right to object. Individuals have the right to object to the processing of their data, particularly for direct marketing. If they object, you must stop processing their data for that purpose immediately. Knowing these principles and rights is one thing, but how do you put them into practice? Let's look at the key steps for achieving GDPR compliance. First, your organization may need to conduct a Data Protection Impact Assessment, or DPIA. This is a risk assessment process for any new project or system that involves processing personal data. It helps you identify and minimize data protection risks before they become a problem. Next, you must maintain a record of processing activities, or ROPA. This is a detailed internal document that outlines your data processing operations, what data you collect, why you collect it, how long you keep it, and what security measures are in place. In certain situations, you may be required to appoint a Data Protection Officer, or DPO. A DPO is an expert in data protection who independently oversees your compliance strategy. Public authorities and organizations that conduct large-scale monitoring or processing of sensitive data usually need one. And crucially, you must implement appropriate technical and organizational measures to secure the data. This isn't just about technology. For instance, a law office might encrypt its client files, but it must also restrict access to authorized staff and provide regular training on data security. This checklist provides a great overview of the essential steps. But what happens when things go wrong? GDPR has very strict rules for data breaches. If a personal data breach occurs, you must notify the relevant supervisory authority without undue delay, and where feasible, within 72 hours of becoming aware of it. This 72-hour clock starts ticking the moment you realize a breach has happened. If the breach is likely to result in a high risk to the rights and freedoms of individuals, you must also inform the affected people directly. For example, if a registry service is hacked due to a phishing attack and sensitive information is stolen, they have a duty to alert the individuals whose data was compromised. Failure to comply with GDPR can lead to severe penalties. Fines can go up to 20 million euros or 4% of your company's total worldwide annual turnover for the preceding financial year, whichever is higher. These aren't just empty threats. Regulators have issued significant fines, making compliance a top business priority. All right, you've taken in a lot of information. Now it's time to test your knowledge with a quick quiz. Don't worry, it's just to help reinforce what we've learned. First question: which GDPR principle requires data to be collected only for specific purposes? Is it data minimization, purpose limitation, accountability, or transparency? The correct answer is purpose limitation. Question 2. What is the maximum fine under GDPR? Is it 10 million euros, 100 million euros, or 20 million euros, or 4% of global turnover? The correct answer is 20 million euros, or 4% of global turnover. Question 3. Which article outlines the right to access personal data? Is it Article 15, 17, 30, or 5? The correct answer is Article 15. Next, who is responsible for demonstrating GDPR compliance? The data subject, data processor data controller, or the supervisory authority? The answer is the data controller, under the accountability principle. Final question: what must be done within 72 hours of discovering a data breach? Notify the data subject, notify the supervisory authority, erase all data, or hire a DPO. You must notify the supervisory authority. Great job! You've now completed this essential overview of GDPR. Protecting personal data isn't just a legal obligation. It's about building trust and respecting individual privacy. Thank you so much for watching. Stay safe and stay compliant.